Partnership is a group of persons who have agreed to share the profits and losses of a business. It overcomes the disadvantages of sole proprietorship in financing, managing, and expanding the business, as many partners can work together. Let us look at the features of partnership. Formation. Partnership is governed by the Indian Partnership Act, 1932, and requires a legal agreement specifying the terms and conditions, including the sharing of capital, profits, and losses. Number of partners. The minimum number of partners is 2. As per Rule 10 of the Companies Rules, 2014, the maximum number of partners can be 50. Liability. The partners of a firm have unlimited liability. Personal assets may be used for repaying debts. Example: A and B are partners in a firm, sharing profits and losses equally. If the debt is 50,000 rupees, each of them has to pay 25,000 rupees. But if B cannot pay due to bankruptcy, A has to pay the full amount of 50,000 rupees. Risk bearing. The partners bear the risks involved in running a business as a team. The profits and losses are shared in the same ratio as agreed upon between the partners. Decision-making and control. The business is run and decisions are taken with the mutual consent of the partners. Mutual agency. Each partner is responsible for the actions of the other partners and vice versa, and is responsible for the business. Let us look at the merits of partnership. Ease of formation and closure. A partnership firm can be formed easily with an agreement between 2 or more persons. Registration is not compulsory. Closure of the firm is also an easy task. Balanced decision-making. Different partners having expertise in different functional areas can take correct decisions with the consent of others. More funds. In a partnership, capital is contributed by a number of partners. This makes it possible to raise large amounts of funds. Sharing of risks. The risks involved are shared by all the partners. This reduces the anxiety, burden, and stress on individual partners. Let us look at the limitations. Unlimited liability. The partners of a firm have unlimited liability. Personal assets may be used for repaying debts. If some partners cannot pay, the other partners will have to pay on their behalf. Limited resources. There is a restriction on the number of partners, and hence capital from only a limited number of people can be invested. Possibility of conflicts. Differences in opinion on issues may lead to disputes. An unwise decision by one partner may harm the business. Secrecy. A partnership firm is not legally required to publish its accounts and can maintain confidentiality. Continuity. The death or bankruptcy of a partner can end the partnership. However, the other partners can continue the business using a new partnership agreement. Lack of public confidence. Confidentiality of the accounts of a partnership firm makes it difficult for any member of the public to ascertain its true financial status. Let us look at partner by estoppel. Suppose Abhishek is a friend of Naveen, who is a partner in a software firm called Simplex Solutions. If Abhishek is part of a meeting where funds are raised for Simplex Solutions based on Abhishek's inputs, then Abhishek is considered a partner in Simplex Solutions. Let us look at a minor as a partner. A minor cannot enter into a valid contract with others, so he cannot become a partner. A minor can share only the profits, but cannot be asked to bear the losses. Once a person becomes a major, he or she will have 6 months to decide, or he or she will automatically become a full-fledged partner in the business. Let us look at the partnership deed. A partnership deed is a written agreement that specifies the terms and conditions that govern the partnership. It includes the following aspects: name of the firm, nature, and location of the business, Duration of the business. Capital contribution made by each partner. Profit and loss sharing ratio between the partners. Duties and obligations of the partners. Salaries and withdrawals of the partners. Terms governing the admission, retirement, and expulsion of a partner. Interest on capital and interest on drawings. Procedure for dissolution of the firm. Preparation of accounts and their auditing. Method of solving disputes. Let us look at the registration of a partnership firm, which can happen during formation or at any time during the existence of the firm. Registration means entering the firm's name and required particulars in the records of the Registrar of Firms Office. To register a partnership, an application must be submitted and the registration fees deposited with the Registrar of Firms Office, which will then issue a certificate of registration to the partnership business. The application will include the name and location of the firm, names and addresses of the partners, date of joining of each partner, signatures of all the partners, and duration of the partnership business. It is optional to get a partnership registered. However, registration is a better option because of the following reasons. A partner of an unregistered firm cannot file a suit against the firm or the other partners. The firm cannot file a suit against third parties. The firm cannot file a case against the partners. Types of partners. Active partner. Meaning, an active partner is one who takes actual part in carrying on business of the firm on behalf of other partners. Capital contribution. An active partner contributes capital to the firm. Participation in management. Participates in the management of the firm. Share in profits/losses. Shares profits and losses of the business. Liability. Unlimited liability. That is, personal assets can be used to pay firm's debts. Sleeping or dormant partner. Meaning partners who do not take part in the day-to-day activities of the business are called sleeping partners. Capital contribution. A sleeping partner contributes capital to the firm. Participation in management. Does not participate in the management of the firm. Share in profits/losses. Shares profits and losses of the business. Liability. Unlimited liability towards the creditors of the firm. Secret partner. Meaning, a secret partner is one whose association with the firm is unknown to the general public. Contributes to the capital of the firm. Capital contribution. A secret partner contributes to the capital of the firm. Participation in management. Participates in the management of the firm. Share in profits/losses. Shares profits and losses of the business. Liability. Unlimited liability towards the creditors of the firm. Nominal partner. Meaning, a nominal partner is one who allows the use of his or her name by a firm. Capital contribution. A nominal partner does not contribute capital. Participation in management. Does not take active part in management of the firm. Share in profits/losses. Generally does not share profit or losses. Liability. Unlimited liability to the third parties for the repayments of the firm's debts. Partner by estoppel. Meaning, a person is considered a partner by estoppel if, through his or her own initiative, conduct or behavior, he or she gives an impression to others that he or she is a partner of the firm. Capital contribution. He/she does not contribute capital to the firm. Participation in management. Does not take part in management of the firm. Share in profits/losses. Does not share profit or losses. Liability. Unlimited liability to the third parties for the repayments of the firm's debts. Types of partnership. Classification on the basis of duration. Basis, meaning partnership at will. Partnership formed at the will of the partners is called Partnership at will. Particular partnership. Partnership formed for the accomplishment of a particular project, say construction of a building or an activity to be carried on for a specified time period, is called particular partnership. Basis. Duration. Partnership at will. It can continue as long as the partners want and is terminated when any partner gives a notice of withdrawal from partnership to the firm. Particular partnership. It dissolves automatically when the purpose for which it was formed is fulfilled, or when the time duration expires. Classification on the basis of liability. Basis. Liability, general partnership. In general partnership, the liability of partners is unlimited and joint. Limited partnership. In limited partnership, the liability of at least one partner is unlimited, whereas the rest may have limited liability. Basis. Participation in management. General partnership. The partners enjoy the right to participate in the management of the firm, and their acts are binding on each other as well as on the firm. Limited partnership. The limited partners do not enjoy the right of management, and their acts do not bind the firm or the other partners. Basis. Registration. General partnership. Registration of the firm is optional. Limited partnership. Registration of such partnership is compulsory. Basis. Existence. General partnership. The existence of the firm is affected by the death, lunacy, insolvency, or retirement of the partners. Limited partnership. Such a partnership does not get terminated with the death, lunacy, or insolvency of the limited partners.